What up, what up, what up? It's your favorite shit-talking squirrel, back from the Darrell Brooks video. So we had another hearing. This one was interesting. We actually did a little watch-along in the Discord, so some of the bits and jokes I might have stolen from a few of you viewers. If you're out there and you know who you are, and you see it, you guys said it was fair play, so I had at it. I mean, you know, the seeds were planted during the, when we watched it, but I was definitely able to expand upon it, a lot of the stuff that we talked about during that viewing in this video. If you aren't in the Discord yet, what's wrong with you? We are having the best time in there. I know some people had said that the Discord link kept expiring. I'm kind of new to Discord myself, but I finally reset it, and I introduced a link that does not expire. So if you go to the About Me page, and you click the link in the Discord, it is now a permanent invite. That link will work, but I'll also put it in the description of this video. I'm not going to make this intro too long. I want to jump into it. I know you guys want to see the DB content, because you're all thirsty for it like I am, but I got another big upgrade for the channel, guys. So everybody, you know, get your little, you know what, here, let's do a drum roll sound effect. Nice, look at that, huh? Yeah, look at me stepping up the quality. And backgrounds! How awesome is that, huh? Somebody put a comment down there and just said, why do you just have the squirrel standing in an ominous black void? And I thought to myself, yeah, why do I have that? So I worked really hard on these. I got the squirrel bedroom. I love this. I made it inside the hole of a tree. I think it's so cool. And then I have I have a couple different like streamer setups here. I'll show you a few of them. It's so cool. Like, the squirrel's out there in the forest just recording YouTube videos. It's so funny to me. And then I have the open concept studio, the forest studio. Pretty nice, right?
Hell yeah. Hell yeah.
If any of you guys are artists out there, I'm probably looking to make some more of these. I mean, as you can see, I'm okay with the art. I mean, I use software, and I kind of touch up here and there. I'm pretty good, but if any of you guys are out there and you are artists, I'm certainly willing to commission you. If you can make me some of these backgrounds, shoot me a message, run into the Discord. If you're looking for work, I am currently in the market, so hit me up. But, alright, beyond that, let's get into the DB content, shall we? Let's just jump on into it. Let's get this.
Thank you, Judge.
All right, he did gave us the thumbs up signal. We're here today to address the state's.
Oh dear, he has officially reached his final form. His power level has officially exceeded 9,000. It's like trial Darrell walked so wheelchair Darrell could roll, and now Zoom court Darrell just teleports in and out, just he just phases in and out of reality as he wishes. He's evolved beyond the need to be physically present in the courtroom finally. And trial Darrell with the mask on, that was like the first stage of the evolution chart. This is like the Darrell Brooks Charizard. He's at the third stage of evolution.
Hell yeah. My name is Darrell Brooks Jr. I am here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in these charging instruments, and I do not consent to or agree to being called that name, Your Honor.
Oh, I swear, he's just doing this, like, for us YouTubers. Because every time he appears in court, he's like a whole-ass new person. Like, you can stop pretending you're somebody else, dude. We still know it's you. Those glasses might be thick, but you fucking, like, you're not Superman up here pretending to be Clark Kent. We can still tell it's you. Oh, man. I swear, he's gonna, like, come to court one of these days with, like, one of those glasses mustache combos, like in disguise. That'll be the next hearing. He'll have like the fucking Mr. Potato Head mustache on. He looks. He looks like if you fused Jeffrey Dahmer and Mr. Potato Head and they did like the fusion dance now.
My name is Darrell Brooks Jr. I'm here as a third-party interviewer.
Oh, Mr. Potato Head probably has more in his head than Darrell, though. Dahmer is certainly more relatable. He's definitely more charming than Brooks. Like, at least he stood up in the court and owned what he did. And that's not to say that, like, these two were anything but complete monsters, but, you know, by comparison, Brooks does make Dahmer look just like a sexually frustrated loner who, like, probably just got left alone to his own devices for too long. We have reached such disgusting levels of depravity with Brooks. Dahmer boiling people's bones and squirting acid into a dude's brain looks tame by comparison standards.
State's request for additional restitution. That letter was filed back on November 30th of 2022. The court had given Mr. Brooks until January 3 to file an objection, and a response was filed that the court interpreted as an objection.
Oh man, the gang's really all here. Darrell up at that bench, Darrell muted on the monitor behind them, Opera and Witchow respectfully letting the judge make an accurate record. We even got Darrell filing obscene nonsense the court has to go through all kinds of hoops just to describe or understand. It's what we interpreted as an objection. It's just a piece of prison note paper with a stick figure drawing of the judge being stabbed over and over again, and the words "Die, Darrow, die" scrolled across the bottom in what appears to be either feces or blood. Man. Just like the good old days.
Since that time, Attorney Covey has been appointed to represent Mr. Brooks in the appellate process, but you are appearing here today, and we are thankful for that. And so the matter was put on. Obviously, it's outside some of the time limits, but I would note the original request was made timely, and frankly, it was due to the court's calendar. Originally, I had been scheduled to be in a 5-week trial starting February 13th. And then that was delayed by 2 weeks, and ultimately that trial was adjourned. And so that was the reason for the hearing being scheduled on today's date. So for now, I don't anticipate your client having...
Oh yeah, that's one thing I should probably mention. Darrell has a lawyer now. I think he's got him for the case moving forward because it's in the appellate process, which is smart because Darrell's abilities, both logistically and mentally, are not equipped nearly enough to what they need to be to weave through the confusing labyrinth that is appellate court. It's a very different game. I mean, it's mostly filing and paperwork, very few hearings. So this isn't 100% surprising. It would have basically been a lot of work on his end for a very small return on investment, like a lot of paperwork for him to go through, which would be difficult in prison. And he's really not getting that much benefit by handling this portion of the case by himself. So I'm not shocked to see the public defender stepping in at this point, even though it is technically the same case.
Client having to talk, I can just hear background, so I'm just going to mute it, and if we need to talk to him, we'll unmute. There'll be a 30-second delay unless he has the device there, but to unmute. But in any event, I think I've accurately stated kind of the timing of the requests. As I understand, the additional paperwork that was filed as recently as April 12th, and I trust you've seen that, Attorney Covey?
Judge, yes, I did see, I think you're talking about document 566?
Yes.
I have that right in my hand.
All right, and so does the state have a grand total for additional restitution the state is seeking?
So to be clear, Your Honor, on the document, is that the one that's titled, well, the first thing is crime victim compensation? Okay, thank you.
Yes, I just couldn't tell if that, I didn't do the math, if that's.
Yes, I wanted to be clear on that. So at the bottom it notes you've already ordered sum of 124,220.65 to crime victim compensation.
Yes.
The grand total that's listed at the top of 134,466.85 encompasses that 124. So this is not in addition to, okay? So our request for crime victim compensation is 134,466.85. For Wilbur and Associates or Hartford Insurance, total request is $108,164.61. Optum subrogation, $118,805.62. Progressive Insurance, $10,000 for victim GGG, and Progressive Insurance, $104,662.64 for victim C.
All right, and I believe your letter of November 29 indicates the additional amounts that you're seeking. And then this document really totals things up.
Yes, it does. And at the bottom, already ordered the EMC insurance for Waukesha School District. That was already ordered, and there's no update to that number, so that number can remain as fixed.
I'm just going to do a quick calculation to determine the additional amount to crime victim compensation the state is seeking. Looks like that's $10,246.20.
I'm sorry, could you repeat that number?
Assuming I hit the keys on my calculator
okay.
correctly, it's the difference between the 134 plus minus the 124, and that's $10,246.20.
Yes, we agree with that.
All right, and then the additional other amounts to other individuals, namely insurance companies, are really those four amounts that are listed in near the bottom of this document to Hartford Insurance, the Optum, and Progressive for two different victims.
Yes, correct.
All right, is that your understanding of what was being requested, Attorney Covey?
Judge, it clarifies things. I had thought that the state was asking for an additional, the full 134,466.85 in addition to the 124. So my number, original number, I thought was just north of 476,000, but it seems like it's closer to about 350,000, give or take. I'm using round numbers because I don't have a calculator with me.
Understood. It's my understanding from the document that you filed on behalf of Mr. Brooks that Mr. Brooks is not contesting the loss that was suffered.
But rather, Mr. Brooks is counter-offering to the victims 6 Maruchan instant soups and half a box of honey buns.
But rather his ability to pay.
Judge, that is correct. I'm not asking for, at least for anything to date, anybody to present extra documentation as to the accuracy of these numbers.
So my client has made out a check from his Sestacue Trust. It's only accessible every 4th full moon, and you have to be guided there by a 3-legged Sherpa named Hummus. He'll put a bag over your head and guide you to the International Bank of Funny Money, located at the corner of Park Place and Boardwalk. It's over Candyland Mountain and across the Valley of Imagination. Then it's just over my Dead Body Bridge, and your next left and you're there. Ask for Math Boy Fly. He'll know what you're looking for.
Imagination. Imagination, imagination, imagination.
It's just on his earning ability and lack of funds.
And was that the state's understanding as well?
Yes.
I know in the filing from Attorney Covey, I don't recall if it was the letter or the actual motion to deny, there's a claim that Mr. Brooks is indigent based upon his incarceration. Is the state going to take any issue with that?
We're agreeing to that fact, Your Honor. We've reached a stipulation with Attorney Covey that recognizes Mr. Brooks, to our knowledge, is indigent at this time, and that his future earning capacity would be limited to prison wages.
And that's an agreeable stipulation to the defense?
Judge, we reached that agreement yesterday. Absolutely, I suggested it.
I don't want to be presumptuous, but I know the last time the court addressed restitution, the state was requesting really an order related to an escrow account. Should there be future payouts or earnings by Mr. Brooks, will you be making the same request?
Yes, and I noted that is in the original judgment of conviction that was filed by the court on November 17th of 2022. You had made that order and that finding at the time of sentencing, and you had also indicated restitution costs and surcharges and fees to be collected from prison monies pursuant to statutory authority. And so we're going to ask both of those orders remain in place.
Will your client have any objection to that?
If there's additional restitution, I don't object to the escrow account.
That would be for monies paid to Mr. Brooks, not a restitution, not an escrow account beyond that. Under 949-165.
I'm sorry, counsel, if I may, just for 1 second.
Hey, just so you know, I really fucking hate this guy. Oh, me too. I really hate him with an unbridled passion. Okay, yeah, me too. Okay, yeah, samesies. Okay, yeah, samesies. Me too. Love you. Bye.
Judge, counsel explained to me briefly what she was getting at. I don't have any objection to that.
All right. Then it seems to me there's really just some legal arguments as to whether I should order the additional restitution.
Yes, Judge.
The stipulation then would put us in a position where Mr. Brooks does not need to testify. That's my understanding, and that would be how I would proceed. Anyone see that any differently? Attorney Opper?
We do not.
Judge, that was the reason why I suggested the stipulation.
All right, thank you. Then, since it is the state's request for additional restitution, I'll hear from the state.
Thank you, Judge. Your Honor, we are asking this court to order restitution in the full amount as proposed in the document we filed yesterday. I think you said it was 566.
Yes, counsel. Here.
Thank you. I'm sorry. I just don't know the document number.
Yes, it is document number 566.
Judge, we certainly understand ability to pay as one of the factors that the court is to consider here, but we'd like to highlight a couple of things. First of all, one of the goals of restitution is to rehabilitate the defendant. We think that is an important goal in this case, noting the damage that was inflicted by this defendant to multiple victims. We would note that most of the monies, or at least a majority of the monies, came from the Crime Victim Compensation Fund, which really is funded by taxpayers. It's a state fund, and that I'm glad to see on this list there's no individual victims. That the desire for the public to have those monies repaid to the CVC if appropriate. As far as the insurance companies, the same, Your Honor. While I understand they operate as a for-profit business, these were substantial expenses that they had to cover for their insured, for their clients, and a direct result of the defendant's conduct and the significant injuries that several of these victims suffered as a result of Mr. Brooks' behaviors.
Man, you talk about the bar being lowered and lowered. I thought making Dahmer look better by comparison was messed up. But I'm now currently empathizing with the insurance companies. The insurance companies! The most corrupt, fucking money-hungry, ethically void corporations there are. Even they did the right thing when faced against Brooks. Like, look, we'll deny you cancer treatment after 60 years of coverage without a single claim. But the Darrell Brooks victims? Oh man, that was fucked up. Just pay them, whatever it takes. That was a tragedy. Jesus. And they did pay out to a lot of victims too. Like, they did the right thing. God. When pitted against Darrell Brooks, it's the insurance companies that come out well. Like versus the insurance companies, Darrell Brooks is the one that's morally bankrupt. Oof.
So we do believe that it's both fair and appropriate for the court to order the whole amount, notwithstanding that limitation. The reality is that perhaps this will never be achieved by Mr. Brooks in his lifetime on prison wages, but it would serve a rehabilitative purpose, because should he ever receive employment within the prison system and a wage, albeit minimum, it would be a reminder to him and aid in his rehabilitation that for whatever monies he earns in the prison, a portion of it does go back to the Crime Victim Compensation Fund. And the other thing is, Your Honor, of course, we don't know if an escrow account would ever be needed under 949.165, but I think we can make a reasonable observation here that there is potential for Mr. Brooks to obtain money in the form of payment to sell his story, to engage in a book deal.
Oh my god, a book by Darrell Brooks. Can you imagine? Penned by the all-caps version of Darrell Brooks. Ghostwritten by a third-party interreader. You'd need an Ebonics thesaurus just to decipher the damn thing. The audiobook would need to be read by fucking howler monkeys. I'd rather listen to dying cats. It was the best of times. It was the worst of times. Is this Admiralty Court or Common Law Court? Are you asking me or are you telling me? Who is the plaintiff? Is the plaintiff sitting in the courtroom here today?
Or a movie offer or whatever it is. We know that this case garnered international attention. It's not beyond the realm of possibility that someone may at some point offer him some funds or some sum of money to share his perspective on this case. And so I would hate for this court to, set $100,000 today and then tomorrow he gets a $500,000 book deal. That would be offensive, I think, and go beyond the scope and the purpose of restitution. So for that reason, Your Honor, even noting his current limited ability to pay, we feel it's appropriate that you order the full amount as requested. Thank you.
Before I turn to the defense, I don't want to make any assumptions, but it's my recollection, probably during the sentencing, maybe even during some of the witnesses, or even during maybe discussion related to jury selection, obviously the community had set up a fund for victims to seek reimbursement. It's my understanding that this restitution amount that's being requested would be larger. I don't know if it would be substantially larger if all losses were being requested by the state.
That's an accurate statement, Your Honor, and I think it's very fair to say it would have been substantially larger if it not had been for the generosity of individuals who contributed to those funds.
Oh, man. It's beautiful that people did that and they were able to help their community so much and so many people chipped in, but it sucks that he's benefiting from that. Just, makes me sick. Again, it was money that was needed, so it's amazing that it's there and that it happened, but it still just pisses me off that it's ultimately going to result in him paying less money because of other people's generosity.
As I recall, were there millions in that fund at one point?
I believe that's accurate, yes, I've confirmed that.
All right, and then I had also heard, but I don't know if there's any truth to this, but that at one point Mr. Brooks himself may have demanded payment to talk to a news organization or some media outlet.
Yeah, so I forget where I heard this story, but apparently Darrell was able to get a phone into his cell, and he reached out to a news organization pretending to be somebody else, like he put on a fake voice, and he was like, "Oh, I'm gonna go get Mr. Brooks, but you're gonna have to pay up. It's gonna cost a pretty penny to talk to Mr. Brooks," and then just like left them on hold for like an hour, and then eventually just hung up, like he never actually did the interview. And then after the fact, the news company was able to confirm that it was just Darrell alone in a cell, like it couldn't have been anybody else. So it was just him pretending to be like his own agent, negotiating for more money. What a loser.
Again, I don't want to make assumptions, but I had heard that at one point.
Attorney Wichow and I are, I've heard that as well, but I can't confirm that with any certainty, Your Honor.
All right, thank you. Then turning to you, Attorney Covey.
Thank you, Judge. Although I'm relatively new to the case, I can state just from my review of the file so far, I haven't heard anything at all about anybody offering any kind of book deal or any kind of sums of money in any way, shape, or form to Mr. Brooks. I think it's the odds of Hollywood knocking down his door to give him lots of money for his life story, I think given the totality of the circumstances of this case, I just think are so minuscule that I don't think that argument should be given much weight. I also couldn't imagine any of the media, whether it's a YouTube blogger or the people that are next door to this courtroom, offering Mr. Brooks any money for some kind of exclusive interview. I cannot foresee the future with 1,000% certainty, but I think the odds of that, again, are just exceptionally low. I appreciate the fact, Judge, that the state's stipulating that he's indigent. I think counsel mentioned minimum, and I just want to make sure that the court recognizes that we're not talking minimum wage as a legal $17, $18, $19 an hour for prison work. If he's offered work in any of the facilities that he's going to be serving time in, at best he'll be getting perhaps a few dimes an hour for janitorial work or cleaning up the kitchen.
Well, Mr. Brooks, I'm so excited you want to join our kitchen cleaning team here at the jail. I'm looking at your resume. Looks like you listed the reason as leaving your previous job at the steam metal factory. I don't know what the fuck that is. Typically, steam is only used to shape wood, but we'll go with it, I guess. You listed the reason as, I got locked up, ... I mean COVID. It was COVID. And then before that, you just put, fuck bitches, get money. Can you elaborate a little bit more on that for me?
The type of wages that are earned by inmates in our correctional system, they're not used to save up lots of money. They're used to sometimes save up to buy a bag of Doritos or some deodorant or toiletries. That's essentially his earning capacity. If they let him work perhaps $1 or $2 a day if he works the entire day. So that's the reality of what he's facing. Judge, counsel touched on this, and I appreciate her argument. Frankly, whether you order $50,000 or $500,000 or $5 million, it's very unlikely that Mr. Brooks would be able to pay even the smallest fraction of that. But this hearing still matters. This is not just a moot point or a moot exercise, because you do have the duty, Judge, to balance 5 sometimes competing factors as listed in Wisconsin Statute 973.2013. I mentioned it in my motion, and then, of course, the 5th factor was I sent a letter to the court about that yesterday. The 5 factors are the amount of loss suffered by any victim as a result of the crime considered at sentencing. 2, financial resources of the defendant. 3, the present and future earning ability of the defendant. 4, the needs and earning ability of the defendant's dependents. And 5, any other factor which the court deems appropriate. Judge, I'll go just a little bit out of order. On subsection 4 regarding Mr. Brooks' dependents, recognizing that he's currently serving multiple life sentences consecutive, realistically, he's not going to be able to support his dependents anyways.
Oh, refresh my memory, Mr. Lawyer. What was the problem before he went to fucking jail then? What changed? It's so stupid. Oh. Yeah, no, God. Judge, don't worry about the kids. Mr. Brooks needs his Doritos. He needs that Dorito money. I know he's $40,000 in back child support that he owes his wife. That technically that money should probably be going to once the victims are paid off, but no. Mr. Brooks needs honey buns. Ugh! Just the hustle never ends with this guy. Like, yeah, even in jail, he's still running away from paying for his kids. Like, there's no chance they're ever going to see a dime of it anyways. But the fact that, like, you know he went up there and he was like, make sure my kids don't get none of that money. I want my fucking honey buns and my Doritos. Oh, man. Oh, his shitardery knows no bounds. Truly, there is no level he is not capable of singing to. He'll always get there.
And so that factor isn't really on point for this hearing. On the first criteria, the amount of loss suffered from the victims, I'm not surprised that the totality could be in the millions of dollars. I'm sure it's an absolutely enormous amount. And you have that discretion to give that factor great weight. I concede that. But I also hope that you consider the next 2 factors as well, and they kind of go together. His earning ability and his current financial resources. I hope that gets great weight as well.
Oh man, I know this guy's just doing his job, but that was kind of hard to sit through. Oh, using the term great weight, right, bumped up next to discussing the money for the victims, that is pretty tasteless. Like, I get this guy has a job too, he's got to defend him, but that was, I don't know. That didn't do it for me. I wouldn't have worded it that way. That's pretty tasteless. Pretty gross.
She's had significant financial problems even before this case. I believe he qualified for a public defender from day one. If he were to testify, he would testify that he had no savings, no assets. He doesn't have any kind of inheritance coming down his way. Nobody owes him any kind of money. I don't think anybody would dispute those facts. If you add on another $500,000 or $350,000 to what he's already been ordered to pay, which is in excess of $171,000, then you are sending a message that the 2 factors, his poverty, his earnings abilities, just don't matter. And I hope that they should be considered. Finally, Judge, subsection number 5 is the catch-all section, where you can consider any other factors which the court deems appropriate. I'm not sure if the amount of restitution in document 566 is the sum total of what might be requested in future restitution hearings. There is case law that states that a request could be made well past the 90 days after the sentencing hearing. We could object to it, but a lot of courts have upheld those. And I believe, just for the sake of judicial efficiency, since he cannot pay anyways, since he really couldn't raise more than a couple of dollars a month anyways, is it worth the court system's resources, our time, the court's time, the community's time, to have potential extra restitution hearings when the ability for him to pay anything is going to be minimal or nil? And Judge, I guess one last thing. I would respectfully disagree that this is about rehabilitation. Given the length of Mr. Brooks' sentence, I think this is just more additional punishment, adding extra zeros to the judgment of conviction for money that he owes.
I don't agree with that whatsoever. He was getting a life sentence on homicide victim number 1. So I would argue rehabilitation through his 1,000-year sentence is the redundancy here, not the garnishing of his wages. The garnishing of his wages is the daily reminder that his life is not his own anymore. That even the smallest freedoms afforded to him in the cruelest conditions allowable by law are also subject to the heavy, heavy burden he should and in fact does carry for the rest of his days. You know, like, the optimist in me likes to think that the small reminder he gets whenever he goes to buy his fucking Doritos or Honey Buns or whatever will prevent him from getting complacent in his surroundings. So he'll never be able to forget Jackson Sparks or Ginny Sorensen or Leanna Owen or any of the other victims that didn't get a portion of their life taken. They didn't get their life garnished. They got it stolen. They weren't sentenced to live in custody. They don't get to live anywhere. They don't get to eat those Doritos or those Honey Buns that he stuffs down his nasty fucking trap. And I don't want him to ever forget that.
I recognize the gravity of the harm, and I mean no disrespect to anybody who suffered any injuries or the medical bills from this case. But given the totality of the circumstances, his multiple life sentences, I just don't think it makes sense to add on any additional restitution. It's just more paperwork, potentially extra hearings for no really just purpose except to add extra numbers on the judgment of conviction. I'm happy to answer any questions you might have, Judge, and thank you.
All right, thank you. First of all, I do want to thank the parties again for the stipulation. I think that certainly has made this hearing one that is running quite smoothly, but also kept victims from having to testify again regarding the loss that they suffered, and even, frankly, the representatives from crime victim compensation or the insurance companies related to this. I also appreciate the stipulation from the state regarding the indigency. I think that's a testament to both counsel here and their willingness to, look at this objectively and what the purpose of this hearing and what the court needs to do. It is true that the court does need to consider the statutory criteria in 973.20. That's been referenced by Attorney Covey, both orally here in court today and in his motion to deny restitution. There are 5 criteria, really, when you look at the statute: the amount of loss suffered by any victim as a result of a crime considered at sentencing, the financial resources of the defendant, the present and future earning ability of the defendant, the needs and earning ability of the defendant's dependents, and any other factors the court deems appropriate, really what we would call the catch-all. Obviously, this concerns a case where Mr. Brooks was convicted of dozens and dozens of crimes based upon conduct stemming from him driving an SUV through the Waukesha Christmas parade. There were 73 named victims, one of whom was the victim of the domestic abuse-related convictions, and then, of course, the 6 individuals who perished as a result of his conduct and the 68 others who were injured. There are family members that are represented by each of those victims as well. This was and remains a very significant crime that has and will have lifelong effects for not just Mr. Brooks, not just these victims, but the community as a whole. And the losses that were suffered apart from the death and the injuries is only in part represented by the dollar figures that have been requested by the state on behalf of the victims. And that's what prompted one of the questions to Attorney Opper is that there was, and I think perhaps, I don't know if it still has any money left in it, but we know that there was a fund set up by community members, really funded, I'm sure, if you were to look carefully, probably internationally, with millions of dollars that helped defray costs and the loss to many of the victims. There was testimony, whether during the trial or probably more at the sentencing, of individuals who did not have insurance and suffered out-of-pocket losses, and thankfully the community stepped up, crime victim compensation stepped up, but it would have been significantly more in terms of the dollar amounts that the state is seeking, but for that fund that had been created and used to help the victims of Mr. Brooks's crimes. And so I think that's an important consideration for this court to consider. In addition to the type of loss that was suffered here, I mentioned this earlier, there was death, great bodily harm, certainly emotional and physical trauma, because this involved a parade and Mr. Brooks driving through it, there's also that sense of security and safety in our community that he robbed not just the parade goers on that fateful day, but really the community, the state. I think anyone who's heard anything about this case would feel a real sense of security that was stolen by Mr. Brooks. I do think the state's argument on rehabilitation is a solid argument. The bottom line is Mr. Brooks completely minimized his conduct both during the trial and at sentencing. And it is important, if only symbolic, that while he is in prison for the rest of his life, that whatever meager sums he might make with a prison wage, that there be a reminder to him why there is this deduction from his monies, that his ability to go to the canteen or to buy some extra item that's not otherwise provided by the prison, that there be that reminder to him that he doesn't have even the full access to whatever money is on his account. Now, I'd remind everyone the law caps what that deduction will be at 25%. I think that's a very clear recognition by our legislature of the balance that the system needs to have as it relates to prison monies. And I think that's an appropriate cap. I also think it's important that this court consider that the vast majority, I shouldn't say vast majority, but a significant amount of the restitution is to crime victim compensation, which is a state fund, largely, if not all, funded by taxpayers. And even if there were some grants that are there from federal resources, which I imagine there might be, that's still taxpayer funded. And so I think that's another consideration for this court to look at and consider. Now, I do have to balance. I'll look at all the criteria. Obviously, significant amount of loss. That's criteria reflected in sub 13 sub A. Sub 13 sub B, the financial resources of the defendant. Clearly, they are extremely limited at this time. However, there is absolutely no doubt in my mind that the possibility exists for Mr. Brooks at some point in the future to possibly profit from a book deal, a made-for-TV movie, a movie, whatever it may be. Maybe it's just doing an interview or whatever the case may be. I don't think that can be ruled out, even if he is obviously the person who was convicted of that, but there was international attention. This court had Court TV in to stream the trial. This court has always streamed every hearing as it relates to this case, in part because of the number of victims, and I could not, I don't have a courtroom big enough in this county to hold all parties involved. Certainly during the trial, this courtroom was packed on a daily basis. To say that the trial went viral, I think, would be an understatement. And so all of that relates to, though, that catch-all factor and the possibility that Mr. Brooks could come into a sum of money at a later point in time because of the story that he could provide or tell on his own behalf. You need only look at Netflix to know that crime stories are incredibly, they're things people want to watch. People find them interesting. People want to know the why. They want to know the how. And it's certainly not just this case, but we've seen it, and not that that's been on Netflix or anything, but other cases have captured the attention. So I don't think it's beyond the, it's not an impossibility, let's say. It's, I think, a very real possibility that someone might produce something someday for more of a commercial or theatrical type purpose, even if it's a true crime type situation. And that it's possible that Mr. Brooks could profit from that. And that certainly is why, at the time of sentencing, the court addressed the request by the state related to the escrow account. I think that's important to do that here. And so when I balance all of these things, when I consider the significant amount of the loss, the court's desire to hold Mr. Brooks accountable, and even if it's a small reminder with his prison monies, that does serve a very important rehabilitative role, because even though he's serving successive life sentences, we all hope that one day he truly is able to accept full responsibility for what he has done, not minimize his conduct, and so that this award of restitution in full, as the state has requested, is important. And I will grant the additional amounts, as I indicated earlier. It's $10,246.20 to crime victim compensation. That total then to them for the judgment of conviction is $134,466.85. Then to Wilbur and Associates, which is Hartford Insurance, $108,000, $164.61. Optum Subrogation, $118,805.62. And then Progressive Insurance for victim GGG, $10,000, and Progressive Insurance for victim Q, $104,662.64. That is, of course, on top of what the court had already ordered to EMC Insurance of $47,193.29. So again, I'll grant the request of the state. We'll also include that it be payable out of any prison monies per state statute, and the court under 949.165 makes the additional amounts of restitution ordered today subject to the escrow account under that statute.
So, I have some thoughts, obviously. I am once again just in awe of Darrell's poignant response. She doesn't mince words. She's so eloquent. She's such a gifted speaker that when these moments happen, during the trial and in these hearings where she finally does get to make her ruling or comment on a subject, I really don't, or at least I try not to kind of stamp all over it with the pause breaks and, my little squirrel quips. I really couldn't see adding anything to her remarks by interrupting, and I know for me at least, I've seen enough of her being interrupted, at least for one lifetime. I don't know about you. At any rate, regarding her ruling, I I do think she does the right thing here, as per usual. I think the defense attorney made about as good an argument you can make, as tactless as it may have been at certain moments. I think he did a good job of representing Darrell. I think he'd be best served to stick by his side. He seems like he knows what he's doing. Given the circumstances and the facts are such that, there's basically no doubt this man did this at this point, especially now he's been convicted. And a lot of other people paid and are still paying for the horror this man caused. So I think the position that, quote unquote, he's paid enough, or, he already got 1,000 years, this is overkill, it doesn't really hold water upon even like the slightest amount of inquiry. Like, even the slightest amount of forethought will see right through that argument. Somebody had to pay because person X was ran over by Darrell. Why is somebody else paying for his crimes? Like, the idea that he shouldn't have to at least attempt to reimburse some of these monies does not feel like justice to me. And it certainly wouldn't feel like the right thing to do in this scenario. So, once again, Darrow is right on the money. I think she said it best when she mentions him dodging of accountability during the trial, and that being a factor in this. The rehabilitation aspect of this has merit, as much as his public defender may protest. If not his wages, then what? Like, for the safety of the community, he was always going to be jailed for life. So at what point do we fit punishment in here? I think she did a really good job by recognizing that and making the correct ruling and summarizing the facts as eloquently as she did. It was just taking the time to recognize that the community at large has been altered. Her comments about the sanctity of the parade never being the same because of this man is very true. And, the community at large probably needs to feel some semblance of justice in this whole thing, as much as the victims may have gotten theirs. I think the recapturing of this money serves, if not a small token in that plight, and I applaud her for not only pursuing that, but taking the time to make sure it was weighed and put on the record and spoken. So, a great job by Darrell as normal, nothing surprising there. Yeah, that's pretty much it, guys. They wrap up some logistical stuff from here, but I thought it was a fascinating hearing. It's new content, so I know you guys wanted to see it. This weekend, we're going to be recording a case with... We're going to be doing a Case Watch episode with Alistair from Pack Nation. If you guys missed it, excuse me, I did a live stream with him last Friday. I will leave a link to that in the description. We had an awesome time. It was a lot of fun. But now he's going to come onto my channel. I'm super excited. Him and me and Nasan, we're going to watch the second half of the sentencing remarks. If you haven't seen the first half of that video on Nasan's channel, it's hilarious. Like, I hadn't watched it in a while, but it is a hammering. Like, we go in on that dude. So I'm very excited to see Nasan and Alistair and how they, will coagulate, and all three of us will be able to hammer on Brooks. I think it's going to be a really good time. We're recording that Sunday. I still have an episode of Case Watch in the can from last weekend that I'm editing, so I wanted to get this out today because it just dropped, but I will be editing that this weekend, so you should be seeing that in the next couple of days. And then next week, probably, we'll record that on Sunday, so it'll be out probably early next week. So look out for that too. And with that, make sure you like this video if you forgot. Gotta drop the likes. Gotta remind everybody to like. Subscribe if you're not. Do me a favor too, and leave me a comment. Let me know what your favorite food is in the comments, so I know you watched this video the entire way through. That way I know who the true OG squirrel pups out there, and who are the fakers. The ones that watch like 20 minutes and then dip out. Alright guys, I love ya. Have a good day, have a good weekend. I love ya. I'm waving, you can't see it, but I'm waving at you. Alright guys, love ya. See you in the next video.